Okay. We're back on YouTube. This is going to be position 51, State of Georgia versus Christopher Antonio Sinkfield. Mr. Sinkfield is charged in warrant number 2022 WA 14262 with committing the offense of lording or prowling. He's charged in warrant number 2022 WA 14263 with committing the offense of obstructing an officer. And finally, he's charged in warrant number 2022 WA 14264 with committing the offense of simple battery. Mr. Sinkfield is in court. He's represented by counsel. The state is also present. Mr. Taylor, would you please call your officer and
Yes, Your Honor.
present your case?
Officer Rios, could you raise your right hand, please? Do you solemnly swear that the evidence you shall give in the matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Could you state your full name, please?
Officer A. Rios,
And what is your occupation and agency?
patrol officer.
And what agency is that with, Your Honor, sir?
Clayton County Police Department.
Thank you. Were you working as an officer on the date September 11th of this year?
Yes, sir.
And did you have occasion to go to the location 7465 Davidson Parkway in Stockbridge, Georgia?
Yes.
Is this in Clayton County?
Yes.
What was the nature of the incident that caused you to go to that location?
We were called in reference to a suspicious person hanging around the hotel area by the manager. And once the first officer that got to the scene, he made contact with Mr. Sinkfield, and Mr. Sinkfield decided to run off on the officer that was out there first.
And did you participate in locating Mr. Sinkfield?
No, when I actually got to the scene, Mr. Sinkfield was already in handcuffs.
Okay. Did the other officers indicate that Mr. Sinkfield had run away from them?
Yes.
And they were at that time, did they indicate to you that they had instructed Mr. Sinkfield to stop running and to make contact with them?
No, they did not.
Okay. What was the reason that the officers were attempting to make contact with Mr. Sinkfield?
Just to see what was his reason of being around the hotel if he was not actually renting a room there.
Okay. And did you or the other officers present make contact with Jeanette Nichols?
Yes.
And what information did you learn from that contact?
That she stated that when she noticed on surveillance camera that he was going around from room to room by looking through windows, she stepped outside. She told Mr. Sinkfield to, hey, can you leave the premises? She said instead of that, he ran up to her and bumped into her. And that's when she called 911.
And this location, 7465 Davidson Parkway, that is a commercial hotel, correct?
Yes.
The stay-in and suites?
Yes.
And Miss Nichols is an employee there, is that correct?
Yes.
So she informed you or the other officers that that Mr. Sinkfield was not a registered guest, correct?
Yes.
Did she indicate that he was there as a guest of another party at the location?
No, she did not indicate that.
And she said, just to confirm, that when she spoke to him and asked him to leave, he made physical contact with her.
Yes.
And this contact was of an aggressive or insulting nature.
Yes.
And the other officers attempted to make contact with him,
Mm-hmm.
and he ran away from them.
Yes.
No further questions at this time.
Mr. Little?
Thank you, Your Honor. So, Officer Rios, when you arrived, my client was already in custody.
Yes, sir.
Okay. So you didn't witness any of the interactions between him and the other officers before you arrived.
No, sir.
Okay. Do you know what description was given for the suspect whenever officers were dispatched?
Yes, the description was a red coat and black pants.
Okay. And what was Mr. Singfield wearing when you made contact with him?
The red coat and black pants.
Okay. What time of day was this?
This was around 2 in the morning, I think so. It was around morning time.
Okay. Was the hotel open?
The management, no, it wasn't open for registry, so nobody could actually book in until further opening.
Do you know when they open? Like they close overnight, so nobody can register
Yes,
overnight?
Yes, they close overnight, and I think they said that the opening would be around 8 a.m.
Okay. When you made contact with Mr. Singfield, did he give any explanation for why he was out there?
No.
Did you ask him for the explanation of why he was out there?
Yes, we asked for his name, and he was completely out of it. He was not in his right state of mind.
What do you mean when you say that?
When I asked for his name, he said that his name was the Lord of the Galaxy, some nature like that.
Interesting. I noticed you didn't write anything about that in your police report about him saying
Then
the galaxy.
yeah, and then after asking him several times, then he gave me the name by Tony.
Tony. Okay. And that's how you referred to him during this investigation?
Yes.
Okay. Miss Nichols told you that she didn't know Mr. Singfield?
No.
Okay. Had she ever had contact with him before this date?
No.
Had he ever been issued like a criminal trespass warning or anything from the property telling him not to be there?
To my knowledge, no.
Okay. Well, you didn't charge him with criminal trespass, right?
No.
Okay. Now as to the simple battery, where does Miss Nichols say she was touched?
Well, she didn't say. Well, she just said he just walked up to her and just bumped her, basically like a chest bump to her, and that was the only initial contact that they had.
But like she didn't indicate where on her body she was touched?
No.
Okay. Did she report any sort of injuries or pain or anything?
No, she did not.
Okay. Were there any other witnesses that you spoke to that would have seen this interaction between Miss Nichols and Mr. Singfield?
No.
Okay. Ms. Nichols told you that she was observing Mr. Singfield on surveillance camera before she made contact with him?
Yes.
Did she show you any sort of recordings or anything from that camera system?
No, she did not.
Okay. Okay. And those are the questions I have at this time.
Okay, Mr. Taylor, do you have any follow-up?
Yes, Your Honor. Officer Rios, who were the other officers that were working the call with you?
It was the first responder was Sergeant Williams, and Sergeant Bigger was out there, and I cannot remember the other officer that was there as well.
Okay. No further questions. Thank you.
Mr. Little, do you have any recross based upon that?
No, Your Honor.
Okay. May Officer Rios be excused?
Yes, Your Honor.
Officer Rios, you can be excused, sir, or you can stay, but you're no longer under any compulsion to remain. Mr. Little, do you have any witnesses that you're going to call?
No witnesses, Your Honor, just argument.
Okay. Ms. Taylor, are you going to waive opening?
Oh, stay waived, Your Honor. Okay.
Mr. Little.
Thank you, Your Honor. Starting with the obstruction, Your Honor, in order to obstruct, Mr. Sinkfield has to obstruct an officer in the lawful discharge of their official duties. I think in this case, what the state would be trying to allege is that he was given a command to stop and didn't stop. However, we've had no testimony as to that, Your Honor. By the time Officer Rios arrived, Mr. Sinkfield was already in custody with officers. Officer Rios was not able to testify anything as to the interaction between the other officers and Mr. Sinkfield. So we don't know the context in which they made contact with him. We don't know how they identified themselves as officers, and we don't know what sort of commands would have been given to Mr. Sinkfield. So we have no way of knowing whether or not he did in fact obstruct those officers, because we don't know what those officers were even trying to do to him. As to the loitering, Your Honor, this is a hotel. It's a business that is open for people to seek lodging at. We did hear some testimony the business may have been closed, but we don't know if Mr. Sinkfield knew that the business was closed at the time, or if he was inquiring for a way to rent a hotel room there for the night. I'm not sure if Mr. Sinkfield was given the opportunity to explain himself. When Officer Rios testified, he testified that Mr. Sinkfield seemed as though he may have been somewhat confused during the conversation, and he may have said some interesting things to the officer. So I don't know if maybe he was in a state where he couldn't properly understand what Officer Rios was asking him, and therefore didn't answer the questions to Officer Rios' satisfaction. But I would point out that this is a situation where he's not alleged to have created any damage. He didn't have a previous criminal trespass warning him to stay away from the property. He's just alleged to have been on that property at night, I guess when Miss Nichols didn't want him to be there. Then, Your Honor, as to the simple battery allegation, my worry there is that I'm not sure how the state plans on accusing this case, not knowing what actually happened to Miss Nichols. She said that she was run into, but she didn't indicate where she was hurt in any way. Typically, when these cases are accused, the state would have to allege how and where and in what context Miss Nichols alleges she was struck. She says that she was struck, but we don't know how she was struck, what she was struck with, or where she was struck. So it's just too vague to meet that standard of probable cause, Your Honor, as to the simple battery. I'd also point out that if there was a surveillance system here that saw the outside of the hotel grounds, if this did in fact occur and there was a simple battery between Miss Nichols and Mr. Sinkfield, that should have been captured on that camera system if it really existed. So, why couldn't Officer Rios look to see what that camera showed to see whether or not there was in fact proof of the simple battery? So without that, proof to indicate the reliability here, Your Honor, I would argue the state's failed to meet their burden of probable cause in this case.
Mr. Taylor, I'll say this to you, Mr. Little, with the simple battery, the testimony about his running up and making contact with her, I think is sufficient at this stage. But I do have concerns about the loitering or prowling and obstructing an officer. So, Mr. Taylor, I hear from you as it relates to those two charges.
Yes, Your Honor. An employee of the hotel calls to report a suspicious witness, or a suspicious person. She indicates that she made contact with the defendant, and she knows that the defendant's not a registered guest of the hotel. So if he's not a registered guest doing business at the hotel, and he has no other purpose of being there, which he demonstrated by fleeing, then clearly he was loitering for the purposes of the statute. He was not, had no other reason to be there except for, I can't think of a legal or a legitimate reason for him to be there, to be on the property. The first step that you take if you're going to register as a guest is you go to the front desk and obtain a room, or you find out if there's a vacancy. If there's a vacancy, you obtain a room. If there's not a vacancy, you leave the premises. There was no indication that that the defendant was visiting another guest of the hotel. And if he was doing so, he would have explained that. He would have had the opportunity to explain that to the hotel employee to state that he was legitimately on the premises. It is private property. He had no purpose for being there. Therefore, I believe the state's met its burden of probable cause for loitering. As far as the obstruction charge,
Hold on. Let me stop. Let me push you on this. Loitering or prowling is being in a place at a time that's not normal and no legitimate purpose.
yes.
If hotel, I don't accept the concept that the hotel is closed. I know they, at a certain period of time, the doors are locked and you got to have a key card to get in. But this is, and I've had this discussion with several other judges, and it's like this person is at a gas station or someplace, and just because it's off hours, that person is charged with loitering and prowling, but that person is there. It doesn't mean the person's up to any good. Doesn't mean the person is doing what they're supposed to do. But the question is, what are the things that you observe to say that this person was up to no good? Now, what I've heard, the allegation of the fleeing is I think more troublesome, and I just need to hear your take on the circumstances of the fleeing when we get to the obstruction. But feel free to respond to my take on the loitering or prowling.
Certainly, Your Honor. First, this incident occurred at between 2 and 4 in the morning. A person arriving at a hotel or coming upon the premises of a hotel between 2 and 4 in the morning with normal business at the hotel would go either to their room or to the front desk lobby area of the hotel in order to register if they hadn't previously registered. That the defendant was not at either of those locations, whether going to a specific room that he had legitimate business with, or going to the front desk indicates that he wasn't at the hotel for a legitimate purpose. And some of the other things that we can take into consideration are how the defendant responded when he was confronted with by the hotel personnel, the employee, and that was he didn't respond by giving his name and saying I'm a registered guest or saying that I'm a guest of somebody else at the hotel. Furthermore, he fled from the police upon the appearance of an officer, and he refused to identify himself. According to Newman, 336 Georgia Appeals 760, these are items or considerations that the court may take into account when determining whether somebody is loitering or prowling. The officers, Mr. Little indicated that there was no testimony that the defendant fled. It was hearsay. However, hearsay being permitted, Officer Rios indicated that the defendant fled from the other officers on the scene. Therefore, he obstructed their investigation of the suspicious person call, and additionally, he failed to identify himself. That in and of itself could be obstruction. He's under no obligation to identify himself, but what Mr. Little gave as being a possible explanation that he was not in his right mind when he said that he was it Lord of the Galaxy? You could also take that as being a false name. I don't especially believe that, but I do think the totality of the circumstances showing that he was not cooperating with the police and was actually trying to interfere with their investigation by fleeing and not at least assisting in identifying himself to so that they could come to another conclusion about the circumstances that brought him to the hotel.
Okay. Well, that was a very good answer. I'm gonna bind all 3 charges over to the state court of Clayton County. And there's, just so you know, Mr. Little and Mr. Taylor, we were supposed to take these things under a totality of circumstances and try to fit the facts into a box. There's not always a clean box. It's enough factors.
I definitely have arguments I'd like to make if I could, Your Honor.
Go ahead.
Your Honor, as to that loitering, we don't know if he went to the front desk, right? The absence of evidence is not the evidence of absence. The fact that we don't have a witness here to say whether or not he went to the front desk just shows the state's not presenting more evidence of what happened here. Like, if we had Miss Nichols to cross-examine, I could very much ask her, did Mr. Sinkfield go and inquire about a room? But we don't know if he went there or not. So that's sort of an open question we still have.
To address Mr. Little, that would be an excellent time to a trial would be an excellent time to cross-examine.
Well, and that's what, yeah, and that's what I was going to say. It's at this stage, it's if we consider earlier in the day when we were much younger, with with Mr. Walker as a witness, and he made statements that I didn't necessarily believe, but at the same time, it wasn't enough to get the state over the threshold of what they had to prove. And in this particular instance, the loitering and prowling was the strongest question that I had. The obstruction of an officer was the middle ground. I had no question about the simple battery based upon the testimony.
And my biggest question was definitely about the obstruction. I think it's telling that Mr. Taylor specifically asked Officer Rios whether or not he knew whether or not there were orders given to Mr. Sinkfield by the other officers, because Mr. Taylor knows he has to establish there's lawful commands being given to a suspect before they can obstruct those lawful commands. So without that testimony as to what those commands were, what is it that Mr. Sinkfield's actually obstructing? He's not charged with giving a false name. He gives the name of Tony, satisfies Officer Rios, who just refers to him as Tony for the rest of the report. If he wanted more information, he could have asked him for more information. He could have charged him with giving him false info if he felt that Tony wasn't a sufficient name for a person whose middle name is Antonio.
I'll ask this. Is it lawful commands or an officer in discharge of their lawful duty?
It has to at least be an officer telling you something, right? If there's an officer walking down the street in their uniform, they're in the lawful discharge of their official duties because they're on patrol, right? But if I see that officer and that officer doesn't say anything to me and I take off running, have I committed a crime? Because they haven't told me to do anything. There's no interaction between me and that officer, even if that officer is in lawful discharge of their official duties.
I'll say again, I don't necessarily agree with the law, but I have to, when I put this black dress on, I have to follow the law. There is a case out of Cobb County where they charged a person with a felony of false statements because the person was pulled over and it was within a investigation as to whether this person was driving under the influence of alcohol. And they asked the person, have you had anything to drink? Person said no. Person blew on the breathalyzer and it was clear that this person had stuff to drink. They charged the person with the felony and they took it all the way up to the Supreme Court. And the Supreme Court said, yes, you can do that. Now, do I personally agree with that? No, but I'm not in that position. Yeah, Mr. Little, you elevate me up to where I can start making law, then things may change. But until that happens, my duty is to follow the law. And I mean, honestly, I joke around with you. I think you're a great lawyer. Mr. Moore is a great lawyer. Mr. Suh is a great lawyer. Getting to know Mr. Taylor today. A jury is where you may end up getting the justice. I mean, and that's just the way it is. And so, Mr. Singfield, your lawyers made great arguments here today. If I was sitting as a juror, I may make a different decision than what I've made today. But as a judge, I have to follow what I believe the law is. So please stay in contact with your lawyer and let your lawyer assist you. Okay, sir? All right. Let's move on to the next case.
Thank you, Your Honor.
Is it Arian Thomas?
Yes,
Or
sir.
Stenfield?
Yes, Your Honor, I'm here.
Or Stenfield, you're gonna get the warrior cross today because you've been holding on.
Hey, I was late, so I'm okay with it.
You have been holding on. At the jail, can we bring up Arian C. Thomas? Okay. For the record, this is position 54, State of Georgia versus Arian Thomas. Mr. Thomas is charged in warrant number 2022 WA 13943 with committing the offense of battery. He's also charged in warrant number 2022 WA 13944 with committing the offense of theft by shoplifting. Mr. Thomas is present here in court. He's represented by counsel. Mr. Taylor, would you please swear in your witness and present your case?
Thank you, Your Honor. Officer Stenfield, Would you raise your hand, please? Right hand. Do you solemnly swear that the evidence you shall give in the matter before the court shall be the truth and nothing but the truth, so help you God?
I do.
Thank you. Could you state your full name, please?
Officer Sheila Stanfield.
And
Clayton
what is your
County.
occupation and the agency that you work for?
I've been working at the Clayton County Police Officer for about 10 years.
Okay. Were you working on September 7th of this year?
I was.
Did you have occasion to go to the location 6937 Jonesboro Road on this day?
I did.
And what was the reason for you going to this location?
Well, it was alleged that the victim called and said he was physically assaulted by a male who also stole some items from the store.
Did you make contact with the victim at that location?
I did.
Is that victim Ajit Singh?
Yes,
And that location is a BP gas station, is that correct?
it is.
And is that in Clayton County?
It is.
When you met with Mr. Singh, what information did he give you about the incident?
Mr. Singh briefly told me what happened. That a male came inside, stole some cell phone charges. He confronted the male, and then they ended up in a physical altercation where the male fought him, punched him in the head, and he also had visible injuries to his hands and knees.
And you observed these injuries?
I did, and took pictures.
Okay. How did Mr. Singh identify the person that caused these injuries?
Well, at first he said a black male who was driving a vehicle, which he also took a picture of the vehicle's tag, and also showed me a video of what happened.
Okay. So you were able to observe the defendant in the video, is that correct?
I did.
How did you make contact with the defendant?
Well, after my investigation from the gas station, and I was driving, and I checked the information that Mr. Singh gave me. We have a system called RMS, where like any officer that made contact with a vehicle, a person, a serial number, you can type that into the system, and it'll tell you when the last time officers made contact with that person. So I checked the vehicle on RMS, and I saw that officers made contact with that suspect the day prior over Mount Zion Parkway. And that report stated that he was driving around. So being an officer for 10 years, I thought maybe he was kind of homeless. And I was like, he might be at the next gas station. So after I left the location, I went to the gas station on Jonesboro Road, which is the QT, and I saw the vehicle, drove around, checked the tag, and it was the tag that was given to me by the victim.
Officer Stanfield, would you do me a favor? Would you turn down the volume on your radio?
Oh, I'm sorry.
No problem, sir.
It's very low. I don't know how you hear it.
So officer, was the defendant present at that location with his vehicle?
He was walking from inside the QT store to the vehicle, matching the same clothing description he had on the video.
Okay. When you observed the video, did the video show the defendant taking items from the stores described by Mr. Singh?
It did.
And what items were these?
It was cell phone charges.
Were the chargers on the defendant's person when you made contact with him?
No. When I made contact with that person, it was about approximately 2 hours later.
Okay. And Mr. Singh, the victim at the BP, gave a description of his car as well?
Yes, and a picture of the tags of the vehicle.
Okay. Do you know that tag number by any chance?
It's on the report.
Okay. No further questions at this time, Your Honor.
Let me ask one question before Mr. Little jumps in. Officer Stenfield,
Yes, sir.
did you compare the images from the video to Mr. Thomas and the person that was in the video?
Yes.
Okay. Go ahead, Mr. Little.
Thank you, Your Honor. So it was at the BP that you saw this surveillance video?
It was a BP gas station.
Okay, and that's where the alleged shoplifting is supposed to have taken place.
Yes.
Okay. Was the shoplifting what you observed on the video? Or the
It was actually
or both or
both.
okay. Now as far as that shoplifting, was there a police officer in that video that you were able to observe?
Yes, there was a school police officer that came to the parking lot around that time.
Okay, did they have an interaction with Mr. Thomas on that video?
He did. When the victim approached him and said he stole something from the store, Mr. Thomas came back in the store. After telling the officer he didn't have nothing, you could see the reaction. There was no audio to the video, but you could see the reaction saying he didn't have anything, but came back inside the store. As he came back, he dig into his pocket, took something out of his pocket and placed it onto the counter.
Onto the counter in the store?
Yes.
Okay. And then what happens on the video?
And then after that, Mr. Thomas proceeded to walk to the shelf again and took another item, walk inside the store for a little bit, and then walk out with another charger.
Is this all while that police officer is still there?
Yes.
Okay. So what? He just leaves the store then without being confronted?
No. Then the victim saw him again, and the victim, as the officer was completing his transaction, the victim again, with the officer, confronted Mr. Thomas. Mr. Thomas entered his vehicle, and you could see in the video he dig into his pocket, took the item out, placed it under the passenger seat of his vehicle, then came outside his vehicle and said he didn't have nothing, and dug to his pocket, showed the officer that he didn't have anything, but he had already taken the stuff out from his pocket and placed it under the seat.
What was it that he took out of his pocket?
It was a cell phone charger again.
And you know it's a cell phone charger because you saw that it was a cell phone charger.
The area where he picked up the shelf where he picked up, that was cell phone chargers. That was all.
Oh, I'm not talking about what he's alleged to have picked up. I'm saying what you saw him took out of his pocket. What that was a cell phone charger.
Well, there's a 99% chance it was a cell phone charger.
But how do you know that? And how are you saying that's a 99% chance?
Because that's what he grabbed from the shelf.
But you don't know what else he may or may not have had in his pockets.
No.
Okay, but so what I'm asking you is, you saw the item come out of his pocket and was able to identify what that item is.
And then he concealed it under the passenger seat, and then came out the car, showed the officer that he didn't have anything on him.
What kind of car was it?
It was a silver car. I don't really remember it. That car.
Officer Stenfield, I think you may have been put on mute.
Yeah, I think you got put on mute. I didn't do it. I promise.
There we go. Let's try that again, Officer Stenfield.
Oh, I'm sorry. It was a silver Infinity.
Oh, okay.
I believe it was, but I'm not 100% sure. But I think that's what it was. Okay,
and this car is in the parking lot of the BP station, and you're observing it on video.
Yes.
Okay. And he was inside the vehicle when he's alleged to have reached into his pocket.
Yes.
Was the door to the vehicle open?
He opened the door.
Was the door open when he allegedly reached into his pocket and took the item out?
Yes, he opened the door, got in the driver's seat, reached into his pocket, and placed the item under the passenger seat.
And
it's really good video.
I mean, it must be, right? That's why I'm asking the questions.
It's really good video.
And you were able to observe then that that was a cell phone charger that was taken out.
Well, I can tell you it was the one item that he took out his pocket and placed under the seat to conceal it before
Okay.
he came out the vehicle and showed the officer that he didn't have anything inside his pocket.
Did
Let me stop you for 1 second, Mr. Little. Officer Stanfield, need to understand that I'm listening for context and clues, and the questions that Mr. Little are asking are really clear.
Okay.
Your responses are not so clear. So I just need you to be mindful that when I make a decision, I have to be clear in my mind of why I did what I did.
I understand, Judge.
So please answer Mr. Little's questions in a way that will help me. Treat me like a 4-year-old. That'll help me understand it. Okay, sir?
Got you, sir.
Thank you.
Thank
Go
you.
ahead, Mr. Little. I'm sorry.
No problem. Officer Stinfield, do we know who that officer was that was on the video?
I don't.
Could you tell from their uniform what department they were with?
It was more likely the Clayton County School Police by the vehicle.
Do they use the same, you were saying the RMS system, that's the system that tracks when officers have contact with subjects?
No, it's the system that we use to make reports, to do everything. We can share. We can actually, if we had prior contact with someone, it's like a record file keeper.
Do the Clayton County Police use that same system, or the Clayton County School Police rather? Do they use that same system?
I don't think they do, but I'm not 100% sure.
Okay. Going back to Mr. to Mr. Thomas being in the car, did that school police officer, when they were investigating, did they go over and look at Mr. Thomas's car at all?
No, he was standing outside.
Standing outside of the car?
Outside the vehicle, yes.
Outside the vehicle, okay. But as far as you can tell, that officer didn't go look inside the vehicle or anything?
No, he didn't.
Okay. Now then, going further onto the video, the officer leaves?
The officer leaves, yes.
Is that before or after Mr. Thomas leaves?
I think the officer lived and left Mr. Thomas and the victim at the location.
Okay.
And let me Mr. Little, let me stop you 1 second. My understanding so far with how I've heard the testimony is that Officer Stenfield didn't interact with Mr. Thomas until 2 hours later.
That's what it sounds like, Your Honor.
Okay. All right. Go ahead.
I actually do want to ask about that. Was it 2 hours after the alleged battery that you were called, or that's just when you were able to make contact with Mr. Thomas? Like, what's the time?
It was after the investigation. That was maybe around 5 minutes later, because the BP gas station to the QT is about maybe 3 minutes.
Okay, so it was just that the investigation at the BP took 2 hours before you went to go look?
No, by the time we were called, what happened is we come into service at 6 o'clock in the morning.
Mm-hmm.
That's when the shift starts. The event itself took place around between 5:30 and 5:52. So I got dispatched over there. Maybe when I got there, it was around 6:25 to 6:30 something. By the time I got there, spoke to the victim, watched the video, and it may have been almost 2 hours after that when I made contact with Mr. Thomas.
Okay. Did Mr. Thomas have any sort of injuries on him when you made contact with him?
I did not see any.
Was his clothing damaged or anything?
No.
Okay. Were there any other indications that Mr. Thomas would have just been in a fight about his physical appearance when you made contact with him?
No.
Okay. So, I mean, your testimony as to the battery is that you saw a subject that you believe met the description of Mr. Thomas getting into a fight with the clerk.
Yes.
Okay. Did Mr. Thomas make any sort of admissions to you about getting in any fights?
Well, when I made contact with Mr. Thomas and then placed him in custody because of what took place, and then we read him around the rights, and then asked him if he would answer questions. First question I asked him.
Mr. Officer Stenfield, that's a yes or no question.
Okay.
Did he make any admissions to you about getting into a fight, Officer Stenfield?
No.
Okay. So then you took him into custody?
I did.
What happened to his car?
It was impounded to a record service.
Did you do a inventory search of that car before it was impounded?
I did.
Did you find a phone charger?
I didn't.
There was no phone charger under the seat?
There was a phone charger, but I don't think it matches a new phone charger.
Ah, okay. Those are the questions I have at this time.
Mr. Taylor?
Yes, redirect, Your Honor. Officer Stenfield, you spoke with Mr. Singh at the BP station,
I did.
and Mr. Singh told you he saw the defendant take a charger from the store and leave the store without paying.
He did.
Mr. Singh told you that he was in a physical altercation with the defendant.
Yes.
And that occurred when Mr. Singh confronted the defendant about taking the charger.
Yes.
And you observed injuries to Mr. Singh.
I did.
Did Mr. Singh tell you who started the physical altercation?
He said the suspect did.
Okay. Mr. Singh told you that there was video of the incident.
He did.
And you viewed the incident, correct?
I did.
On the video.
Yes.
You observed the defendant taking the charger on the video?
I observed him taking an item off that shelf, which only has cell phone chargers.
You saw him take an item from the store?
Yes.
You saw him leave the store without paying for that item?
Yes.
And that was on the video?
Yes.
You saw the defendant strike Mr. Singh on the video?
I did.
The defendant, when you made contact with him, was he wearing the same clothes that you observed the person on the video?
He was.
No further questions.
Mr. Little? Do you have any recross?
No, Your Honor.
Okay. May Officer Stenfield be released?
Yes, Your Honor.
Okay. Before I do that, Officer Stenfield,
Go ahead, sir.
what happened to the school resource officer?
Well, Your Honor, it's very complicated when it comes to school police. I don't think they are mandated to do anything when it comes to enforce the law in Clayton County. So I guess that's why he overlooked it.
Yeah, I tell you, I get phone calls in the middle of the night for warrants from them. So
Yes, Your Honor, that's the only thing I can tell you about the school police officer.
okay. All right. Thank you, sir. You can be excused. And or you can stay. Mr. Taylor, you gonna waive opening?
Yes, Your Honor, I'll waive.
Mr. Little?
Thank you, Your Honor. First, starting with the battery, Your Honor, at this point, I'm not going to make any specific arguments as to the battery. I think we'll let that evidence develop more as the case works further. As to the shoplifting, however, Your Honor, I would allege that the states failed to meet their burden of probable cause in this case. What we had was testimony from Officer Stinfield that he was able to observe a video from surveillance of this BP. That video showed that there was a law enforcement officer on scene. That law enforcement officer had the shoplifting reported to him. They spoke to Mr. Thomas. They had an opportunity to investigate. They saw that he had nothing on him, and they did not choose to charge him with shoplifting. Officer Stinfield's allegation that there was shoplifting in this case comes from his observation of a surveillance video in which he says that Mr. Thomas took something from his pocket and concealed it under the seat of his car when he was in the parking lot of the BP. Officer Stinfield is not able to tell us what that item was, just that it was some item that appeared to be taken out and concealed under the car. And then later, when Officer Stinfield conducted an inventory search of that vehicle, he did not find a cell phone charger that he alleged was stolen from the BP. We don't know what, or if anything, was placed under the seat of Mr. Thomas's car. We certainly don't have any evidence that it was something illegally taken from the BP store, especially given that that incident was investigated by an officer that was on scene at the time that this allegedly happened, Your Honor.
Yes, and I'll tell you, I mean, just in all due candor, that the testimony about the video is compelling to me, but I'll listen to Mr. Taylor.
Yes, Your Honor. The officer testified that he observed the defendant on the video take an item from the store and leave the store without paying for it. That's shoplifting. The officer also testified that he spoke to an employee of the store who also personally observed the defendant take the item from the store and walk out of the store. So we have a video that the officer observed, and we have the eyewitness identification of the defendant and their testimony, well, not their testimony, but their information to the officer that this defendant took an item from the store. Whether it's a phone charger or not is immaterial. And whether the officer, the school resource officer, a police officer, did a thorough investigation or not is immaterial. The officer that testified today did a thorough investigation. He watched the video. He identified the defendant as a suspect. He acted on that information, located the defendant, and positively identified him based on his observation of the video, the description given by the victim, and by the clothes he matched with the defendant wearing the same clothes. The fact, or what's not a fact, but the information that we have currently that the officer didn't find an item from the store within the defendant's car is not conclusive. The defendant left the location and he had an opportunity to dispose of the item. That it's not in the car when he was later made contact with the defendant, when the officer made contact with him, doesn't mean that he didn't have it in his possession and didn't take it from the store earlier. Therefore, also, as to the battery, the defendant was observed striking the victim on the video. We have the information provided by the victim that he made contact with the defendant in regards to the shoplifting, and there was a confrontation, and the officer observed physical injuries on the defendant, on the victim. So based on the information, I believe the state has met their burden of probable cause in this matter for both the shoplifting and the battery.
The testimony about the video is the thing that saves this case for the state, for me. The testimony is kind of all over the place. But officer says he came in, he looked at video, he saw confrontation with the alleged defendant and the alleged victim. And that's enough. The testimony about seeing the alleged defendant take things away, items, I think that's sufficient. I think from a trial standpoint, not having that may be a problem down the road. But right now we're at 51%, and I think the state has reached their 51% threshold. So this case is going to be bound over to the state court of Clayton County. Let me ask this question. It looks like from my records, I have one hearing left, but I see a number of, no, I have 2 hearings, but I see officers here. Does anyone believe that we have more than 2 hearings left?
I know I'm expecting Victor Williams and Stanson Williams, Your Honor.
Those are the 2 that I have.
Yes,
Your Honor,
I believe I'm done for today.
Okay.
Your Honor, it looks like we have Officer Sterling here. I believe he came in after the announcement that the Chambers matter had already been accused. And let's see, were we going to have a hearing on
Demons?
Demons is for the Edwards matter, Your Honor. I was unsure if we were going, I know we were going to have a bench conference with Your Honor, but I was unsure if we were going to move forward with the hearing or not today.
Oh, with the administrative bond over. So